Hello friends, in the series on the income tax cases, today we will discuss a very important case regarding the additions on the allegation of receipt of own money by a builder on the basis of the statement of his senior sales manager. Nowadays, a number of the notices are coming both to the seller and the buyer that they have received the own money on account of sale of flats, and at the same time to the purchaser also that they have paid the own money to the builder for purchasing their flats on the basis of searches made and on the basis of some generalized statements. This issue has been taken up by Honorable Pune I.T.A bench in the case of Ganraj Homes LLP versus Assistant Commissioner of Income Tax, and this case is reported in 123 I.T.A Tribunal at page number 630. The date of the judgment is 7th February 2025. The facts of the case are very interesting. In the present case, the assessment year related are assessment year 17-18 to 19-20. In the present case, the Assessee was a private limited company and it has been converted into an LLP, and the Assessee was involved in a real estate business. The Assessee has entered into an agreement with a party K to develop some piece of land on the basis of revenue sharing by both of them. There was a search on the Assessee, and in that search, the statement of the working partner of the firm was taken, and also the statement of one senior sales manager was taken. When the statement of the senior sales manager was taken, it was admitted by the senior sales manager that the firm in which he is a manager is receiving the money in cash as an own money transaction for the sale of the units or flats by them. At the same time, when the statement of the partner was being taken, at that time even a single question was not asked about the statement given by the sales manager, that your sales manager is saying that you have received this own money account. So regarding this, a single question was not asked. When the notice under section 153A subsection 1 clause A was sent to the assessee for the assessment, the assessee filed a return declaring a nil income, and during the assessment proceedings, the assessing officer, on the basis of the statement of the senior sales manager, alleged on the assessee that the assessee has received the own money related to the 15 flats. So since the assessee has received own money for the 15 flats, so it is a very high probability case that the assessee must have received the own money account for the other units sold by the assessee also. And at the same time, the assessing officer said that when you have received the own money related to the sales made in a year, then again it is a very high probability that you have received this own money regarding the sale of the flats for other years also. So on the basis of the guesswork and on the basis of the rough notings, the assessing officer took a rate of 20% of the sale consideration mentioned in the sale deed as own money, and the assessing officer made an addition which is equal to the share of the assessee according to the agreement of the assessee and the K. The assessee filed the appeal before the CIT appeal, which was rejected. So when the assessee was before the tribunal said that in the present case, the whole additions have been made on the basis of the guesswork and the notings and on the basis of the statement of senior sales manager. The tribunal said that first of all, the statement of a person cannot be termed as an incriminating material. It is a tried law. And the tribunal said that all the additions have been made on the basis of the sales manager by ignoring the fact that when the statement of the partner was being taken, the partner was not confronted with the statement of the senior sales manager that the senior sales manager is accusing that they have received the own money account for the sale of the flats. This question was not countered with the partner of the assessee. The tribunal said that even during the search or after the post search or even during the assessment proceedings, even a single buyer was not sent a notice regarding the examination that when it is alleged that the assessee has received the own money, so whether they have paid the own money for the purchase of the flats. The tribunal said that in the present case, the assessing officer stand that on the basis of the sale of 15 flats, assuming that the assessee has received own money for the sale of other flats also, it is a very guesswork, and on the basis of guesswork the additions cannot be made because every agreement is a different agreement. The addition on the basis of one agreement cannot be made in the cases of other agreements. The tribunal said that in the present case, since the addition in the hands of the K, which was the partner or which was the joint venture of the assessee, has been deleted by the CIT appeal by saying that the impounded document were incapable of testifying the AO stand that the assessee has received the own money. So the addition in the hands of the assessee is also deserved to be quashed. Friends, the nutshell of the case is that only on the basis of the statement without having any concrete incriminating material, the additions for own money cannot be made. At the end of this video, once again I am repeating the name of the case. The name of the case is Ganraj Homes LLP versus Assistant Commissioner of Income Tax, and this case is reported in 123 I.T.A. Tribunal at page number 630. The date of the judgment is 7th February 2025. Thank you, friends.